Good morning to all of you. Welcome to Legal Matters by Sai Baba Sunkara. This video is particularly to the law of taught students. Friends, in the last class, we discussed the first general defense, that is volunty non fit injuria, which says that if you volunteer, if you consent for the tort, you cannot claim any compensation. The second exception is plaintiff the wrongdoer. Is a peculiar situation. Plaintiff himself is the wrongdoer. This is based on the legal concept ex turpi causa. Ex turpi causa non-oritur action. That means from an immoral cause, no action arises. So if you do an illegal act and you want to get compensation, definitely you will not be given. Here, as a defense, you have to understand that if the defendant is able to prove that the plaintiff himself caused the wrong, or the plaintiff himself is the wrongdoer, definitely defendant can be free. He need not pay any compensation to the plaintiff. Of course, it all depends on the proof. For law, proof is 100% necessary. Preponderance of facts. Now, we'll go to a couple of examples, very famous examples, old examples we are giving you because you are in the student stage, you have to learn them definitely. So, first case is Pitts versus Hunt, 1990. So, Mr. Pitts is a young boy, aged about 18 years. He was sitting on the backside of the defendant, Mr. Hunt. Mr. Hunt was driving the scooter or the two-wheeler in a drunken stage, and Mr. Pitts encouraged him to such an extent that this man lost control of the vehicle. That means he drove the vehicle in a rash or negligent manner in the wrong direction and hit some pole in a drunken condition, and the rider died. Of course, Mr. Hunt died on the spot. Anyway, he has filed a case against the legal heirs for compensation. Pitts filed a case against the legal heirs of Mr. Hunt for compensation. But they are able to prove that Mr. Pitts has encouraged, he is the wrongdoer. He has asked the man to go in a high speed, due to which this incident happened. And the Queen's bench outrightly dismissed the claim against the defendant, stating that he himself is the wrongdoer. Right? So the plaintiff was contributory negligent for the offense. 100%. He is also having the contributory negligence. Actually, I want to tell you contributory negligence in a separate chapter. It is also very good defense. This is the case. Now, second case. It's also important. Arvind Kumar versus Sunil Mittal, 2010. Here, please remember, when you want to vacate a person from your land, then the first thing you have to prove is that the land is yours. If you are not able to prove, he will not go. This is what happened in this case. So, Arvind Kumar, he claimed against Sunil Kumar Mittal, Sunil Mittal, to vacate the place. The Punjab and Haryana High Court held that when the appellant could not prove as the owner of property, then he cannot get compensation, as he himself was the wrongdoer. So he himself could not prove it. Then how can he claim eviction? It's not possible. Third case, Ashton versus Turner and another, 1981. Right. Ashton versus Turner and another. Actually, Ashton and Turner, both of them were, I can say, criminals. Both of them went in a car and committed burglary. They committed burglary. In the return journey, actually, this Turner fellow, he was in a drunken stage, and both of them were coming back en route. They have actually somebody stopped and they have picked up another person also. While returning, what happened is they heard the siren of the police vehicle. Police vehicle was coming from backside. సో దొంగలు ఎవరంటే భుజాలు తడుపుకున్నట్టు దొంగలు ఉన్నప్పుడు ఆటోమేటికల్గా వాళ్ళకి కొంచెం లోపల భయం ఉంటుంది. సో దేర్ ఫోర్, being afraid of the police, Mr. Ashton, he has actually literally put pressure on Turner to go at a high speed. Already he was in a drunken stage. He was driving the vehicle in an attempt to escape from the police. On hearing the police siren, he dashed against a person, as a result of which against a wall, as a result of which Mr. Ashton as well as the other passenger, both of them received injuries. Now coming to the point of Ashton. So here the judge dismissed his claim because as a matter of public policy, law would not recognize the duty of care owed by one participant in a crime to another. Both of them are a participant in the same crime. So one criminal cannot go against the other, stating that this man. No doubt, here you may get a doubt that crime is different. This is the rash or negligent driving. Here also, the encouragement on the part of Ashton is there, due to which Turner, even though he was in an inebriated condition, but he cannot claim the compensation. He himself is the wrongdoer. The claimant had willingly accepted the risk of the negligence and the result of injury resulting from it. You will be knowing, because when once you are asking him, come on, go fast, go fast, go fast, you know that if something happens, you will be injured, is it not? So inviting the same risk, you have asked him. So you yourself are the wrongdoer. So therefore, this is the concept of plaintiff the wrongdoer. So please remember these examples, because it may come as a small question having maybe 2 or 3 marks. You need not much concentrate on this, but anyway, better to learn it. Thank you very much.